Yes, we'll start.
Permit me to do that. Good morning. We are in now for the second session of the day. This particular session is dedicated to the role of the judges in divorce proceedings. We have this morning with us for the opening remarks Honorable Justice Ritu Bahri. What a blend of the bar and the bench. 23 years at the bar, 12 years on the bench. Rich experience and also chairing the committee on family court matters of the Honorable High Court. Speaking personally, Justice Ritu Bahri, I have enjoyed my association. Right from a college, university days to the bar, and I had the privilege of arguing cases before her. It has been an enriching experience of this association. What a good human being and what contribution she has made. We are looking forward to your opening remarks in this particular session. Over to Justice Ritu Bahri.
Good morning to everybody, and thank you very well, Dr. Balram Gupta, for speaking so well for me. And well, one has learned a lot in these 12 years, and I'm lucky that I have an occasion to interact and to share my views with all the judicial officers who are dealing with the family courts. And it is something which is part of our culture. We see everybody around in families, and we see the importance of a family in our entire life. And family in our society means the foundation of growth of every human being. So emotions are part of growth. And in this backdrop, we can all interact and exchange our views. And at the outset, I don't want to give a very long lecture or an introduction, whatever, but I can share only one thing with all of you is that the High Court has already decided, and it is in the process of amending the family court rules of Haryana, Punjab, UT, and High Court. And we are proposing to have counselors who will assist the family law courts, 3 counselors who will assist the family law courts in these matrimonial disputes, so that whenever a case comes, the family court can take assistance of these counselors, and these counselors will have meeting with the families. They can even go to their house, see the environment of the child, and then give their advice and make a report. So the time limit fixed as per the amendment, which is being to be is on the process, is about 1.5 months. So this, because we have been getting requests from the family court judges also to have counselors. So this process that is why I'm only going to say about this amendment now, because that will hopefully bring out a change in the decision-making powers also, and even in giving consultation to the families or the educated parents about the process in which they should lead a divorce proceeding if they can't stay together, and how to look after the needs of the child, which is the most important thing in this region. And I'm sure you must be aware, all of you, that in the mediation, the 75% or 70% cases are matrimonial disputes. So that's a big cult of litigation, which the mediations also have to face. But since the rules are now being in the process of being amended in all the 3 states, in both the states, UT as well as the High Court, so these counselors will be appointed, will have a background of social science, psychology, clinical psychiatry, and they will be working under the family courts, monitored by the family court officers, and then give a report. Even their fee structure has been revised so that we attract good talent from at every district level to assist the courts. And my experience is that pre-litigation state cases which are registered in the police stations, they should also be referred for mediations for counseling, because that is the stage when they require maximum counseling and advice to be given. So these are the amendments which are in the process now, and hopefully it will be carried out. So that will make a substantial change in the way to deal with matrimonial disputes. Of course, the law is very settled, but sometimes the advice is required at the initial stage when the parties separate. By the time they come to High Court and Supreme Court, many years are lost, and they can't go back, and they can't even repair their mistakes which they made in the initial years. So this is what we are proposing for all the three states, and this has been finalized, almost finalized. It will be sent to the government eventually. So apart from that, my personal experience in one case is that there was a couple who had come up in appeal, who after 13B divorce had patched up, young couple, and they had two children. So incidentally, that day there was another couple who had come for who was seeking, they were in appeal of a divorce had been granted. It is my experience that I sent that couple to sit with, both the couples were sent together to sit for an hour and a half. And the second couple came back and said, we'll also patch up. So sometimes the judges and the lawyers and the mediators can't give so advice where the realistic advice is given. So that couple who was there had got divorced. They decided to patch up for their children. So realities sometimes are required to be told to the litigants. That is why if counselors are there, they can give the realities of a child who's suffering. Because my experience, what I've interacted with the psychologist is the children start stammering, they lose their memories, they can't speak well. When they go through the stress between the parents. So that is where at least we have to be a little bit more sensitive. And of course, otherwise, on the other side, giving there is one issue also that if a 13B divorce is to be given and the party is not in India, can it be given through virtual? There was a judgment which we had passed, which was upheld by the Supreme Court, that even registration of marriage can be done virtually. But the general power of attorney has to be sent to one of the parent. So we have to crease out the technical hitches so that the families who have decided to part ways, even virtually their statements can be recorded if power of attorney is sent to one of the parents. So these are the small things which require improvements, but this amendment will come. I'm sure it will make a difference in the family law courts in the times to come. And now, Dr. Balram Gupta, you can start off with your conference.
Thank you so much.
Yes.
Showing the path forward has been the object of this morning session as such. Your observations would go a long way in guiding the judges and the resource persons to deal with those particular issues as such. This session is being shared by two resource persons, one our own from the Academy, Madhu, Khanna, Lalli, and Mr. Anil Malhotra. I'm so happy to introduce both of them. Madhu, with a good academic base, joined as a judge, long judicial experience. In the year 2012, she came to the Superior Judicial Service, and last year she came to the Academy, being part of the faculty as such. You know, the faculty of Chandigarh Judicial Academy, we are proud of them. They contribute and contribute immensely in this particular process. This workshop, she has worked hard, and I'm sure that the contribution that she's going to make in this particular session, as also tomorrow as well, would be a guiding factor for the family court judges for the future to deal with various issues as such. I'm equally so happy to introduce Mr. Anil Malhotra, who of course doesn't need any introduction, particularly in the domain of the family matters of family law as such. I've known him since 1980 as a student, as a co-runner in the profession, and as an author. He argues cases, writes, authors, books, and this combination, that his books are based upon the cases that he has argued in the other cases as such, enriches the legal literature, particularly in the domain of private law. I've been associated with his books in one form or the other. And therefore, the experience that he brings in would go a long way in generalizing this particular workshop relating to the family court matters. Thank you so much, Anil, for sparing your time to be with us this morning. May I now request Madhu to carry forward the session. Madhu.
Thank you, Dr. Balram Gupta. Good morning, everyone. It is a privilege to address very learned and distinguished audience. But due to constraint of time, the subject of my presentation is limited only to certain aspects of divorce under the Hindu and Muslim law and the ancillary provisions. If marriages are made in heaven, as Tennyson said in Eleanor's Field, why make a matrimonial home hell is a big question. The provisions relating to divorce categorize situations in which a decree for divorce can be sought for, but merely because such a course is available to be adopted should not normally provide incentive to persons to seek divorce unless the marriage has irretrievably broken. Effort should be to bring about conciliation, to bridge the communication gap which led to such undesirable proceedings. People rushing to courts for breaking up of marriage should come as a last resort, and unless it has an inevitable results, courts should try to bring about conciliation. The emphasis should be on saving the marriage and not breaking it. This is more important, as Lordship has also pointed out, in cases where the children bear the brunt of dissolution of marriage. The worst affected victims of divorce are probably the children. The most traumatizing situation for a child is perhaps seeing one's parents getting separated. Being the constant witness to fights and emotional turmoil among his or her parents is certainly an unfortunate circumstance for a child. As for a child, both his parents are dear to him or her. Being away from one of them can hamper his emotional state of mind severely. It has been held in case titled Rosie Jacob versus Jacob A. Chakramakal, AIR 1973, Supreme Court 2090, that the children are not mere chattels, nor are they mere playthings for their parents. In these circumstances, it has to be kept in mind that the child is both a hope and a promise for mankind. The greatest gift we can give our children are the roots of responsibility and the wings of independence. Often it is seen that in matrimonial proceedings, the interest of the child takes a backseat. In divorce proceedings, including divorce by mutual consent, the parties are so engrossed in their bitter fights that the welfare of their own child is lost sight of. It is here that the court must guide them. In mutual consent divorces, the parties settle all the terms and conditions before approaching the court, and we, as judges, seldom scrutinize those settlements. At times because we do not care, and at times with the thought that it may disturb the arrangement between the parties. However, in this rigmarole of thoughts, we miss the most important aspect of securing the future of the minor child by ensuring that a reasonable amount of maintenance has been kept aside for the child. Since Section 13 of the Guardians and Wards Act categorically stipulates that the welfare of the minor is the paramount consideration, therefore it is also the paramount duty of the court to ensure that while parting ways, the parents have taken all due care to secure the future of the child and have a writing to that effect also, be it in the form of a gift, as pointed out by the Lordship, or in the form of a fixed deposit for the minor child, by creation of a trust for his benefit, a health insurance, or an insurance policy. There must be some means for securing the future of the child in the terms and conditions settled between the parents. In matrimonial matters, the financial conditions of the parents and their affluence must be considered, and it must be ensured that the amount left aside for the minor child is sufficient to cater to his future needs. It is also the duty of the court to verify about the self-acquired as well as ancestral properties of the parents and ensure that the share of the minor child in the said properties is secured in accordance with law. The interest of the child must be kept in consideration even if the mother is relinquishing her claim in the property of the father. Then we'll come to divorce by mutual consent. What are the requirements? Under Section 28 Special Marriage Act 1954, Section 32B of the Parsi Marriage and Divorce Act, Section 10A of the Indian Divorce Act 1869, and Section 13B Hindu Marriage Act 1955. A joint petition is required to be filed by the spouses. They must have been living separately for a period of 1 year, though of course it is 2 years under the Indian Divorce Act. They have not been able to live together and they have mutually agreed that marriage should be dissolved. Living separately should be immediately preceding the petition of the divorce. Now, what is living separately? This has been explained by the Honorable Supreme Court in case titled Sureshta Devi versus Om Prakash, AIR 1992, Supreme Court 1904. So it has been observed that the expression living separately means not living like husband and wife. It has no reference to the place of living. The parties may live under the same roof by force of circumstances, and yet they may not be living as husband and wife. The parties may be living in different houses, and yet they could live as husband and wife. So what seems to be necessary is that they have no desire to perform marital obligations, and with that mental attitude, they have been living separately for a period of 1 year, immediately preceding the presentation of the petition. Now, there is waiver of the cooling off period. In a divorce by mutual consent, there is a period of waiting for 6 to 18 months. This interregnum was obviously intended to give time and opportunity to the parties to reflect on their move and seek advice from relations and friends. In this transitional period, one of the parties may have a second thought and change the mind not to proceed with the petition. In the landmark judgment of Amardeep Singh versus Harveen Kaur, 2017, Volume 8, SCC 746, it was observed that the cooling period of 6 months is not mandatory, but it is directory. It was held that as the period mentioned in Section 13B2 is not mandatory but directory, it will be open to the court to exercise its discretion in the facts and circumstances of each case. Where there is no possibility of parties resuming cohabitation and there are chances of alternative rehabilitation. So it is if a case is made out to waive the statutory period under Section 13B, subclause 2 of the court can do so after considering certain facts. I'll just enumerate those facts. First, the statutory period of 6 months specified in Section 13B, subclause 2, in addition to the statutory period of 1 year under Section 13B(1) of separation of parties is already over before the first motion itself. Second, all efforts for mediation or conciliation, including efforts in terms of Order 32A, Rule CPC, Section 23(2) of the Hindu Marriage Act, and Section 9 of the Family Courts Act to reunite the parties have failed, and there is no likelihood of success in that direction by any further effort. The parties have genuinely settled their differences, including alimony, custody of child, or any other pending issues between them. So these are the factors which have to be considered by the court before waiving of the cooling off period. And the last but not the least is the waiting period will only prolong the agony. So these are the factors which the courts have to consider. Otherwise, the cooling off period cannot be waived off. The waiver application can be filed 1 week after the first motion, giving reasons for the prayer for waiver. If the conditions mentioned hereinbefore are satisfied, the waiver of the waiting period for the second motion will be in the discretion of the court concerned. It has to be kept in mind that the object of cooling off period of 6 months before grant of decree of divorce is to safeguard against hurried decision if there is a possibility of reconciliation. So if the court is satisfied that there is no possibility of reconciliation, then it can go ahead. Object is not to perpetuate purposeless marriage or to prolong agony of parties where there are no chances of reconciliation. There's another case, Jai Shankar and another versus Nil, 2021 SCC Online, Madras 708, where the husband and wife had been living separately for 13 years. So there also, the relying upon Amardeep Singh's judgment, the cooling off period was waived off. Now it has to be remembered that the consent of the parties must be free. It should be free from force, fraud, or undue influence. In Punjab, there's a citation, Anuradha Sameer Venengot versus Mohandas Sameer Venengot. May I request Mr. Malhotra to switch off the mic?
Sorry.
Thank you so much.
Sorry, thank you.
It's fine. The Honorable Apex, this is 2015, Volume 16, SCC 596. In this, the Honorable Apex Court has held in the fact, first I'll just give you the brief facts. The wife was suffering from cancer. She agreed to divorce by mutual consent in consideration of rupees 12.5 lakhs as full and final settlement from husband. So it was held that the instant case, it is the primary duty of the husband only to provide facilities for the treatment of the petitioner wife. This is pre-existing duty of the husband, provided the husband has sufficient means and he is diligently doing his part in taking care of her. By the settlement agreement, the respondent husband is promising to do something which he is already bound to do. Then it is not a valid consideration for the settlement. So here the consent was not free. Navdeep Kaur versus Mahinder Singh Ahluwalia. Here again, this is 2010, Volume 2, Marriage Law Journal, 400. Honorable Punjab and Haryana High Court has again discussed that the paramount thing which is required to be considered by the court is correctness of contents of the petition filed, and also to see that consent of either of the parties has not been obtained by way of force, fraud, or undue influence. In this case, the parties were appearing through attorney. So it has been, as a matter of caution, it has been stated that in the absence of the parties, where the attorney appears, the courts have to be more cautious and vigilant in recording its satisfaction about the consent. So now there are cases when the parties are absent, maybe in the second motion. So it is a settled legal position that consent cannot be presumed by the absence of the parties. In case titled Samriti Pahadia versus Sanjay Pahadia, 2009, Volume 13, SCC 338, Honorable Apex Court has held that consent cannot be presumed by the absence in court of one spouse at the end of 6 months cooling off period. Then in Ramola Mandir versus Charanjit Singh Mandir, 2015, Volume 3, Law Herald 2556. It was held that where one of the parties is absent during the course of second motion, the trial court should afford at least one opportunity to the party to appear for second motion before dismissing the joint petition, as the same is moved jointly by the parties under section 13B. Now, withdrawal of consent of the parties. The parties can withdraw their consent at any time. In case titled Avnish Sood versus Tithi Sood. The aspect was discussed. There was another case, Sarishta Devi versus Om Prakash. A party to the petition can unilaterally withdraw his consent at any time till passing of the divorce decree. If subsequent motion seeking divorce decree under subsection 2 is not of both the parties, because of withdrawal of consent by one of the parties, court gets no jurisdiction to pass the decree. The mutual consent should continue till passing of the decree. There's Anil Kumar Jain versus Maya Jain, where the Honorable Apex Court granted divorce under Article 142 Constitution of India, where the withdrawal of consent by one party, even expiry of statutory period of 6 months, was resulted in the petition. Now, in case Rajesh R. Nair versus Meera Babu, AIR 2014, Kerala 44. In this case, the issue that was raised was whether once a consent is given and later on it is withdrawn by one of the parties, can the court inquire into the bona fides or otherwise of the withdrawal of the said consent? The answer is no. It is not for the court to probe into the bona fides or reasonableness of withdrawal of consent. And once consent is withdrawn, the only option available to the courts is to close the matter at that stage. Now, there are cases where benefits have been received by the parties. Now, Deepak Singh versus Pooja, 2016, Volume 2, RCR 742. Honorable Punjab and Haryana High Court has held that if the party that receives money retracts from mutual consent, such a party would be required to restitute the amount so received. It is a duty is cast upon the court seized of such disputes to restore parties to the position on the date of filing the petition. Then there's another case, Ravinder Kumar versus Rekha Rani, 2016, 182, PLR 461. Here also the amount was received by the wife, but she retracted from making the second statement. So it was held that the amount which has been received by the appellant, consequence of the statements made at the first motion, is liable to be restored to the respondent. Where parties filed a petition for grant of divorce by mutual consent and recorded statements in first motion, and wife received certain amount, it was held that the aggrieved spouse cannot maintain an appeal against the dismissal order. The only remedy available is to file appropriate application before the district judge or the family court, as we have family courts now, praying for refund of alimony. So there's no provision of appeal. It is the application that has to be made in the same court. This was held in Vikas Verma versus Harpreet Kaur, 2016, Volume 1. Law Herald 688. Now, withdrawal of consent in second motion shall not attract contempt proceedings in every case. But if an agreement was executed between the parties or any undertaking was given in the court, any attempt to resile therefrom would amount to a breach of the undertaking accepted by the court and therefore attract contempt proceedings only if certain conditions stipulated in the agreement were agreed, acted and violated. Now I'll refer to Avnish Sood versus Tithi Sood again. This is 2012 SCC Online 2445. Here an MOU was executed wherein it was agreed that the parties will seek divorce. Thereafter the parties approached the court. As a one-time settlement, rupees 7 crores was to be paid. In the first motion, 1.5 crores was paid by the husband to the wife. But the wife did not come for making statement in the second motion, despite the undertaking given to the court. So it was held by the Honorable Delhi High Court that once the respondent has taken advantage of the agreement entered into, the terms of the settlement cannot be withdrawn by the respondent to suit his whims and fancies to the detriment of the petitioner. Here the parties were, the petitioner was held liable for civil contempt, the wife. Hirabai Bharucha versus Piroj Shah Bharucha, AIR 32/1945, Bombay 537. It was held that if a contract between the spouses recording the terms of settlement runs against the public policy, then it must be treated as void ab initio and unenforceable in law. In those circumstances, contempt proceedings cannot be resorted to. Then Shikha Bhatia versus Gaurav Bhatia and others, 178. This is 2011, DLT 144. Here the wife had filed an FIR against the husband. The husband filed the anticipatory bail application, and during pendency of that petition, a settlement was reached between the parties to the effect that parties will seek divorce by mutual consent. And the husband will pay rupees 8 lakhs to the wife at different stages, and all the pending cases between the parties will be withdrawn by both the parties. Acting on that settlement, the anticipatory bail was granted to the husband, and he was also paid certain amount to the wife. Thereafter, the husband did not comply with the terms of the settlement, and the court held him guilty for contempt of court. The Honorable Court observed that the respondents, once having taken the advantage of the agreement, entered into the terms of the settlement, then they cannot be withdrawn by the respondent to suit his whims and fancies and to the detriment of the petitioner. There's another case, Prakash Alumal Kalandari versus Jahnavi Prakash Kalandari, AIR 2011, Bombay 119. Here it has been held, which we all know, that the consent to continue till the end. If the consent is withdrawn, the court is left with no jurisdiction to grant a divorce by mutual consent. If the petition is filed simpliciter under section 13B of the Act for divorce by mutual consent, the court must satisfy itself that the consent given by the parties continues till the date of granting decree of divorce. Even if one party unilaterally withdraws his or her consent, the court does not get jurisdiction to grant decree of divorce by mutual consent in view of the mandate of section 13B. However, the situation would be different if the parties in the first instance resort to petition for relief under section 9 or 13, and during the pendency of such petition, they decide to invite decree for divorce by mutual consent. On the basis of agreed arrangements, if the parties were to execute consent terms and then file a formal petition, in the latter proceedings before the decree is passed, one party cannot be allowed to unilaterally withdraw the consent if the other party has already acted upon the consent terms either wholly or in part to his or her detriment. So simple withdrawal of consent would not attract contempt, but the other conditions as mentioned In Dinesh Gulati versus Ranjana Gulati, MAT Act FC 70/2016, it was alleged in a divorce filed on the mutual consent that the wife was not cooperating with the husband. So in this case, suo motu contempt proceedings were initiated by the family court. It was held that a suo motu contempt proceedings neglects the mutuality aspect provided under Section 13B of the Act. And once the parties were unable to or did not wish to proceed with the agreement for mutual consent divorce, then the only recourse was to restore the original divorce petition. Now, whether the parties can record statements in second motion through attorney? Yes. This was held by Honorable Punjab and Haryana High Court in Jaspreet Kaur Dhaliwal versus Pulvinder Singh, Law Finder Document ID #749017, where the trial court did not doubt the bona fides. I'll repeat, did not doubt the bona fides of the parties or legality of the prayer. These conditions have to be satisfied for dissolution of marriage, to insist upon the personal presence of parties, particularly where parties admittedly residing abroad would perpetuate injustice, wastage of time and money. In such circumstances, trial court should not insist upon personal presence of the party to record statement in second motion. Then in Rajwant Singh Bains versus Kulwant Kaur Bains, 2014, Volume 3, PLR 320. As per law, party in a divorce petition can appear through power of attorney or attorney who is also a relation to the party. Not otherwise, relation to the party. Statement can be recorded through power of attorney. Then in Amardeep Singh's case, courts have been permitted to use the medium of video conferencing in conducting such proceedings under Section 13B of Hindu Marriage Act. And even in this case, it was held that close relations such as parents or siblings, where the parties are unable to appear in person for any just and valid reason, as may satisfy the court to advance in the interest of justice. So it has to be valid reason, not otherwise. Now there's another case, Santhini versus Vijay Venkatesh. Here the validity of proceedings conducted through video conferencing by the family court was taken into consideration. It was observed that the role of a counselor in family court is basically to find out what is the area of incompatibility between the spouses, whether the parties are under the influence of anybody or for that matter, addicted to anything which affects the normal family life. Even in the custody matters, the counselors assist the child if she is of such age to accept the reality of incompatibility between the parents, and yet make the child understand that the child is of both parents, and the child has a right to get the love and affection of both the parents. So it was observed that to what extent the confidence and confidentiality will be safeguarded and protected in video conferencing, particularly when efforts are taken by the counselors, welfare experts, and for that matter, the court itself for reconciliation, restitution of conjugal rights or dissolution of marriage, etc. So it is certainly difficult in video conferencing, if not impossible, to maintain confidentiality. It was also observed that the footage in video conferencing becomes part of the record, whereas the reconciliatory efforts taken by the duty holders referred in the judgment are not meant to be part of the record. So in reconciliatory efforts, physical presence of the parties would make a significant difference. So in this judgment, it was opined that the directions issued by the Honorable Court in Krishna Veni Nigam versus Harish Nigam needed reconsideration on the aspect of video conferencing, and therefore the matter was referred to larger bench for consideration. So the finding of larger bench is reported in 2018, Volume 1, SCC, page 1. So as per majority view, it was held that video conferencing in absence of consent of the other party would be contrary to Section 11 of the Family Courts Act. Physical presence of both parties in matrimonial proceedings held in camera is essential as it creates environment of trust, confidentiality, privacy, and emotional bond. Video conferencing at the first instance without consent of both parties would create a dent in settlement process and affect affirmative rights of dignity, privacy, and choice, particularly of women. Once settlement fails and when joint application is filed, or both parties filed their respective file memorandum for hearing of the case through video conferencing before family court, in that event, it may exercise its discretion to allow such prayer or after failure of settlement, if family court considers it appropriate, having regard to facts and circumstances of the case that video conferencing would subserve cause of justice, it may so direct. The dissenting view came from Honorable Mr. Justice Chandrachud. It was held that video conferencing does not negate postulates of in-camera proceedings, even if such proceedings are desired by one of the parties. And it was observed that video conferencing is gender neutral and is capable of maintaining privacy. There's another case, Anjali Brahmwar Chauhan versus Naveen Chauhan, 2021, SCC Online, SC 38, where Honorable Supreme Court allowed video conferencing in matrimonial matters, but though not as a matter of course. It was observed, taking note of Santhani versus Vijay Venkatesh's case, which I just referred to here and before. It was observed that proceedings in all courts are being conducted only through video conferencing since March 2020, due to physical functioning of the courts having been stopped. Therefore, video conferencing can be resorted to, but not as a matter of course. So in Balwinder Singh versus Suman Rani, there are many cases in which in the first motion, in the consent, divorce by consent decrees, video conferencing has been allowed. So due to paucity of time, I'll just rush through. In it, we'll talk about the Muslim law as well. In India, as per provisions of Section 2 of Muslim Personal Law, Shariat Application Act 1937, the Shariat law is made applicable to all Muslims for deciding their personal matters, which includes the matters of dissolution of Muslim marriage. The Shariat law is a comprehensive code of behavior that embraces both private and public activities of Muslims, and it also provides a complete judicial system. In case titled, the names have not been disclosed, 2021 SCC Online Kerala 2054, the jurisdiction of family courts has been upheld in deciding the matters of pertaining to talaq. Now, forms of divorce by consent under Muslim law are khulla and mubarak. Now, this has to be remembered that it is essentially an act of the parties and no intervention by the court is required in this case. The parties can come for a declaration if they so desire. I will not go into details of khulla and mubarak. The wife has right to seek dissolution of marriage under the provisions of the Dissolution of Muslim Marriages Act 1939. And after the enactment of the Muslim Women Protection of Right on Marriage Act 2019, the pronouncement of talaq at once is an offence in India. Now coming to the jurisdiction, Section 19 of Hindu Marriage Act stipulates, I'll not go into the details, stipulates the places where the divorce, where the parties can file the petition. The word resides must mean actual residence and not a legal or constructive residence. It certainly does not connote the place of origin. In order to give jurisdiction on the ground of residence, something more than a mere temporary stay is required. It must be more or less of a permanent character and of such a nature that the court in which the respondent is sued is his natural forum. This is Jivanti versus Kishan, 1982. लगाना जल्दी. Now there are cases where the child is living with the mother. So we have to see whether the child has been forcibly removed only to create the jurisdiction at a particular place, or the child was continuously living with the mother since long. So I'll cut short the judgments also, which I wanted to refer on this aspect. So there are other cases. There was another query with regard to proof of marriage. Haryana Compulsory Registration of Marriage Act 2008 makes it mandatory that the marriages should be every marriage that has been solemnized in the state of Haryana and Punjab to be registered irrespective of caste, religion or creed. Now, registration certificate is the best proof of marriage. Marriage can be proved through photographs, invitation card, or even by an affidavit. Now, there was a query from the officers with regard to transgender marriages. The law has given basic right of companionship only, which should be consensual, free from the vice of deceit, force, coercion, and should not violate the fundamental rights of others. There is no acceptance of the institution of marriage between two individuals of same gender, either in personal law or codified statutory laws. In Arun Kumar and another versus the Inspector General of Registration and others, a marriage was solemnized between a trans woman, both professing Hindu religion. It was held that it is a valid marriage in terms of Section 5 of the Hindu Marriage Act. The registrar of marriage was bound to register the same. So due to paucity of time, I've just cut short the presentation. Now I'll request Mr. Anil Malhotra to take over. Thank you so much.
A very good afternoon to you all. Honorable Justice Ritu Bahri, my teacher, Dr. Balram K. Gupta, whom I affectionately address as Lord Denning, and legal guardians of families. At the outset, I'm very, very indebted and grateful to Honorable Justice Ritu Bahri, who has, ever since the inception of the High Court, taken the step forward of reorienting the rules for the family courts. And I owe this training, I owe this discipline to the Karta of the co-personary of judges, Justice A.L. Bahri, father of Justice Ritu Bahri, who continues to guide us in his ripe age of 90s and has always been a source of inspiration to me as a young lawyer who joined the bar in '85, and his path-breaking judgments on whatever jurisprudence he dealt with was always the guiding path for judges and lawyers. Now, before I enter into the arena of limping marriages, as I call them, which Satya versus Teja Singh identified 42 years ago in 1975, I pose some questions which I, as a mechanic with a toolbox, lug around all over the country and which have arisen to me. Now, every morning when I see for 5 newspapers I find in them scores of advertisements of substituted service, trying to serve erring spouses in Italy, in Germany, in Canada, in Sweden. And then every day I look at the CPC and I wonder to myself, why do we resort to Order 5, Rule 20, which talks of substituted service? Why have we not changed to Order 5, Rule 25, which came in after the judgment of the Supreme Court by Justice Sabharwal, where service was allowed by courier, by email, by fax, and other alternative means? My proposition is, when a marriage is limping, it needs to be resolved. When you pose a newspaper notice, it takes 3 months or 4 months before anything gets anywhere. And who is reading Tribune, Pioneer, or Chardi Kala in Italy, Germany, or France? So I seriously think that the High Court rules should incorporate a provision at par with Order 5, Rule 25, which says that where the defendant resides outside India and has no agent in India empowered to accept service, summons should be delivered to him at the place where he is residing and sent to him by post or by courier or any method approved by the High Court, by fax or the electronic mail service, to be as the High Court rules may provide if there is postal communication between the place and institute outside. So we seriously need to change this concept, outmoded concept of substituted service by newspaper notices, because I honestly, to me, it's only a prolongation of a misery which doesn't serve any purpose. So this is one humble suggestion I have. The second glaring issue which I find often in limping marriages is a domestic violence petition cannot be filed in the family court because the jurisdiction is under the Prevention of Women from Domestic Violence Act 2005. But what happens if there is, let us say, in one court in Chandigarh or in Punjab or in Haryana, a domestic violence petition before a judicial magistrate and a same list between the husband and wife and the child in the family court? Can they be clubbed? The question has been taken by me recently to the Supreme Court, but this is an inconsistency which will need to be resolved at some point of time. The third issue which I find in limping marriages is that the spouse who comes to India, sometimes the woman, takes an interim custody order under Section 21 of the Prevention of Women from Domestic Violence Act. So the foreign court wants to know, is this remedy conclusive? The answer is in the Prevention of Women from Domestic Violence Act, because it says the independent remedy is available, and the substantive remedy is under the Guardian and Wards Act or the Hindu Marriage Act or the Special Marriage Act, as the case may be. The second is parents, spouses come complaining that the order of the family court has not been complied with. Is execution the only answer? Or does the power lie with the High Court to issue contempt under the Contempt of Courts Act? Because under the Contempt of Courts Act, Section 10 says that the High Court can take notice of the court's contempt or violation of the subordinate courts also. But how many have been filed? How many have been entertained? So there is something in the rules which probably will need to cover this as well. Then another issue which probably can be addressed in the rules is, if there are interim orders passed by the family court which are not appealable under Section 19 of the Family Courts Act, how are they to be challenged? In Bombay, they are challenged by a writ petition under Article 227 of the Constitution. In our court, they are challenged under 227 and they are tabled as a civil division. So I think some nomenclature to define the challenge to the interim orders would be necessary, because under Section 19(4) of the Family Courts Act, interlocutory orders cannot be challenged under the Family Courts Act itself. Now, with this brief introduction, I now come to an area which I will speak minus judgments, because eminent speakers before me have led to you a rich knowledge, a data bank of citations on probably every aspect. So I would not wish to repeat, and I would not wish you to be burdened with more citations. I have circulated a concept paper in which I have given all the citations. My ninth book, Global Indian in the Law, contains a plethora of law, but I will talk to you about human beings, lives, because you are guardians of families. You are not family court judges. Your purpose, your laudable goal, your pious duty is to bring harmony into the home. And I'm very happy to see that there are such large number of energized young officers who are manning and donning these posts, and they are treating this as something of a conscientious duty which they must fulfill to achieve the lofty goals of the Family Courts Act. Now, guardians of families, we are a population of 1.3 billion. Now, approximately 30 million of us live in about 200 countries, and we are labeled as overseas citizens of India, persons of Indian origin, or plain and simple NRIs. India itself is spread over 3.28 million square kilometers to about 29 states and 7 union territories. And for me, as a mechanic with a toolbox going to a family court in Goa or in Chennai or in Bangalore, even that jurisdiction is alien to me. But it is the Family Courts Act which gives the umbrella, which is a central model to bring together a resolution dispute forum, which has come in late but still has been introduced in our jurisdictions. I would often find that there was a family court in Punjab or Haryana or in Chandigarh, but because it was not notified, the district judge was still referring matters to the subordinate judge, if it was the guardian and ward act petition, or a matter was going to the ADJ if it was a divorce petition. That resolution is, of course, taking place now. But then the biggest dilemma which is now creeping up, because irretrievable breakdown of marriage is not a ground for divorce, is what do you do with the foreign divorce decree which is before you? So I think we need to first understand the basic concept that once parties are Hindu by religion, irrespective of whether they are Germans, Canadians, Americans, Britishers, or Australians, they have a different passport, they have a different domicile, they will remain Hindus by religion. And the Hindu Marriage Act section 1 and 2 says that the Act has extraterritorial application. So this means irrespective of your domicile, irrespective of your nationality, irrespective of your citizenship, you will still be Hindu by religion. What does this effectively mean? So if you have a Hindu marriage solemnized under section 7 of the Hindu Marriage Act by performance of Saptapati, and we all know registration is optional, it is a conclusive Hindu marriage for all intents and purposes. Now, the law laid down by the Supreme Court in Narasimha Rao's case is that Hindu marriages solemnized in India according to Hindu law can only be dissolved by a court of competent jurisdiction in India. Nirja Saraf's case went a little far to say that there should be a statute to this effect. But the fact of the matter is that this is a concept which has been explained further by Justice Rajiv Raina, whom I had the benefit of assisting as an amicus in Rupak Rathi versus Anita Chaudhary. Now, this was a case of a young couple from Haryana who had gone to the UK. The wife participated in the husband's petition for divorce by irretrievable breakdown of marriage. You all know irretrievable breakdown of marriage is not a ground for divorce in India. And at some point of time, she withdrew from the litigation and initiated a divorce petition in the family court, or it was a district judge at that time in Panchkula. The husband walked up with the matrimonial decree dissolving the marriage by a decree of divorce. In England, there is a decree nisi and there is a decree absolute. Decree nisi is granted for the asking. Decree absolute is made when you settle matrimonial property and custody of children. So when decree absolute was presented before the district judge in an application by the husband, claiming that the court had no jurisdiction because the marriage had been dissolved, the court dismissed the application and the matter came up in revision before the High Court. And the High Court expounded the principles laid down in Narasimha Rao's case. And the bottom line was, which is a very useful elucidation of the law, it says the validity of a marriage decree of divorce by a court of foreign jurisdiction will be tested on the anvil of section 13 and 14 CPC. So if any of the ingredients of a marriage under section 13 and 14 CPC is not satisfied or the exceptions fall in, then the decree is null and void. So the straight answer is, if it is a decree of divorce on irretrievable breakdown of marriage, it is no good, it does not serve any purpose, and the court is bound to reject the decree of divorce. What next? So the answer is, if an application under Order 7, Rule 11 CPC is presented to you, seeking to dissolve the marriage on the preliminary ground of maintainability, you are free to reject it, saying it is not a valid marriage. And then what do? You will have your own pleadings, you will have your own substantive petition, you will have the evidence, you will coin issues, and you will decide. And the foreign decree may be one part of your conclusive decision if you wish to go into on merits. Now, on another note, which I will address tomorrow, is the procedure which a family court ought to adopt in a matrimonial proceeding or a guardianship proceeding. And this has been expounded by the Supreme Court by Justice Khanwilkar in a brilliant, illuminating judgment where I had the opportunity to assist the Supreme Court on what should be the procedure in a family court. That we will take up tomorrow. But coming back to the discussion. So you as the family court, under section 12 and section 14, I would very, in a nutshell way put, you are the Chief Justice of your own court. After you comply with the substantive procedure of the Family Courts Act, the Hindu Marriage Act, or the Guardian and Wards Act, you are free to devise your own procedure on what you have to do, on how you will handle the proceedings before your court. I've had the opportunity of conducting some matters in Delhi, where I find that the family court judges with seniority and age and experience have come out with very illuminating ways and methods of recording evidence, of coming down to issues, taking documents not admissible under law of evidence, breaking away from the shackles of procedure. And I think one way of breaking away from CPC is the substituted service. You are free to adopt an email, which of course is an option available to you under CPC also. But my humble suggestion to you as a practitioner, because I am perhaps the only person amongst you all who's on the other side of the fence, is please decide expeditiously. Please decide whatever you think is right or wrong. You lay down the law. Supreme Court does not lay down the law. Supreme Court will only affirm or reverse what you will lay down as the law. So you are the makers of law. Unless you apply your mind, unless you think in an innovative way, you think out of the box, which liberty is given to you under section 12 and section 14, we will not be able to evolve law. The pandemic in 2 years has multiplied, and there is an explosion of family law litigation. I happened to do a webinar with Justice Hema Kohli and Justice Alistair MacDonald of the High Court of London, of the Family Division, and the view was unanimous that COVID has taught us to come up with new measures in new times. We have to cull out methods whereby we can put limping, we can dissolve limping marriages, or we can put together spouses in limping marriages. So in this larger perspective, I have seen two developments which have taken place in the Maharashtra jurisdiction, particularly the Bombay family court in Bandra, where there are 15 judges in one building. The principal judge has 14 additional judges, and he has appointed child independent lawyers to assist him in proceedings wherever there is a child. Because every litigation between spouses of parents for child custody is treated as a divorce petition. It is more of a battle of contest of the rights of parties. Who looks at the child? Nobody. So there is a voice of the child, there is a right of the child to be heard, and who projects it? Child independent lawyer. So if using this facility which is provided under the Family Courts Act itself, under Section 12 and Section 13, to have an amicus, I am free and available to any family court to assist as an amicus online whenever anybody needs me. But please do try and generate a breed of amicus lawyers to assist you in your jurisdictions. Among the younger generation, there is a bright spark of lawyers as well who will be able to assist you. And if you can build up some specialist family law lawyers in your jurisdiction to assist you, limping marriages can be dissolved in a more amicable way. Now, let's get the bull by the horns. What do we do with foreign decrees, and what do we do with jurisdiction of foreign courts and family matters is the topic which I have been asked to address. Now, the problems which I am asked to answer in way of an expert report as an expert evidence in foreign jurisdictions is, what is the validity of a foreign divorce decree? I am often instructed by spouses to ask, I have a Hindu marriage and I have an American civil marriage. Where do I file a divorce? I have property in both jurisdictions. How will we dissolve property? Are child rights decided in one jurisdiction conclusive in India? Now, these are questions which come because 30 million people have moved up and down and have habited foreign countries. The sad part is they don't want to start litigation in India because everybody thinks it's going to take very long. I often tell them, you need to find a method out of the box. We can solve the problem. So let us suppose you have a marriage which is broken down and in which there is a foreign divorce decree. Now, to the extent the foreign divorce decree dissolves the marriage if one has taken place in the US by civil rights, that dissolution of marriage is good for that civil ceremony. Insofar the Indian marriage is concerned, it has to be dissolved in India by a court of competent jurisdiction. Now, the nitty-gritty is, how do we do this? Law has developed. Justice Ritu Bahri very well pointed out that the High Court has not only permitted dissolution of marriages online, it has also permitted registration of marriages online. I think we are probably going to expand in this jurisdiction with this enlightened view, and Justice Ritu Bahri heading the Family Court Committee, where we will have a new set of propositions coming forth. So the advice given to parties is, you are still going to be married in India. So what is the answer? The parties turn around and say, there is one petition under the Domestic Violence Act. There is one petition under 125 CRPC. There is also an FIR under the 406-498A with the Dowry Prohibition Act. There is also a guardianship petition. So there are, let us say, 5 or 6 litigations which are pending in India. They will not come to an end if you dissolve the marriage. So the consensus advice to the parties is, you draw up a settlement in the US court, laying down what your marriage has in India to be dissolved. And after the dissolution of the marriage, subject to whatever happens in India, keeping back separation of matrimonial property and child custody issues at abeyance, so that pressure is there to resolve in India. You don't come to India, as Justice Ritu very well pointed out. You can apply for a divorce online. You appoint your father, brother, mother, or any family member as your GPA. The GPA appears before the Honorable Court, identifies you, you sit in the foreign jurisdiction and hold your passport. You are identified as the same person. Both spouses appear through different counsel or the same counsel in a 13B petition. First motion is recorded. The second motion may be waived or not. I will come to that in a little while. And the foreign settlement between the spouses can be treated as the terms of settlement before the Indian court, and ultimately the dissolution of marriage under the Hindu Marriage Act in your court, let us say, that settlement will form part of the proceedings and be read as a conclusive settlement to dissolve the Hindu marriage according to Hindu law, so that parties are treated to be divorced in India also. This will free them of bigamy, because there are often cases where a marriage is disrupted because it is only dissolved in the US and it has not been dissolved. So if police walks into the second marriage ceremony and says this marriage is to be stopped, such kind of a situation can be obviated. Settlement of matrimonial property in India can be sorted out. Child custody rights can be sorted out. Child custody is the worst litigation which spouses take on to take revenge against each other, not realizing the irreversible damage they do to the child. So to put a full stop to the child custody litigation, it should be decided. There should be a parenting plan. There should be shared custody. There should be joint custody, or there should be singular custody. Whatever parties agree to, the matter should be solemnized, sorted out conclusively at that stage only, so that there is not another fresh round of litigation. Now, the Supreme Court has recently come up with a judgment in which they say that there is concurrent jurisdiction. So if there is a couple sitting in the US and there is a couple sitting in India, and they have moved permanently, domicile may be there, the court in the US has concurrent jurisdiction. But earlier, the view which was taken on domicile in Sundar Gopal's case was that the permanent domicile jurisdiction remains with India. So Supreme Court has a varying concept, but the fact of the matter is, as far as India is concerned, whatever arises within your jurisdiction, and Section 19 is very liberal to you in terms of accommodating a petition, particularly once there is a 13B settlement, which is arising between the parties. So with this broad perspective, I think what is very important in foreign decrees is that they can be resolved without going into a controversy of their being valid or their being invalid, because that is a procedural aspect which acquires no sentiment. Now, the question is, what happens if there are parallel proceedings between two jurisdictions? Now, this has become a very litigated area, because the moment one spouse in Australia faces an uncomfortable litigation, he runs and comes to Mumbai and files another petition. Then the spouse in Australia comes running and starts a new category of suits, which are probably not very well known in this part of the country. These are called anti-injunction suits. Now, under Section 7 of the Family Courts Act, the proceeding for a suit or proceeding for an order or an injunction in the circumstances arising out of a marital relationship are within the purview of Section 7. Now, I happen to take an objection in the Delhi High Court in a matter where an anti-injunction suit was passed seeking restraint of the father to proceed with the family court proceedings in Delhi on the ground that proceedings were pending in the US. I took an objection before the High Court that this anti-injunction suit has to go to the family court because the High Court has no jurisdiction. Delhi itself, the suit was filed in the Delhi High Court because Delhi High Court is a High Court of original jurisdiction. we are not in Punjab and Haryana. Bombay, Calcutta, Delhi are suits of original jurisdiction. So the objection taken by the council was that it is a suit for injunction, not an anti-suit injunction. So Justice Mohan interpreted it by referring to a full bench that an anti-suit injunction is a part of a suit for injunction. So the anti-suit injunction concept, which came from commercial matters, is now used in family law matters to say that between the same parties on the same dispute, the same list, two proceedings ought not to go on. And the principle of comity of courts and principle of forum convenience demands that the litigation should go on in one forum only. Now, the court in India or court abroad cannot stop each other. But the court in India and the court abroad can stop the parties before them who are same in the litigation in the other jurisdiction not to pursue the litigation in that jurisdiction. So such type of suits are known as anti-injunction suits. So anti-injunction suits are now a common parlance because litigation is sought to be stopped. An anti-injunction is very difficult to obtain because convincing the court of the jurisdiction is a difficult task. Foreign courts tend to grant the anti-injunction more liberally. Sometimes when parties don't stop or courts don't agree, the fate is sometimes sad because there are conflicting decisions. Normally, if a court is told that the matter has reached a substantial stage, it does stop initially, but sometimes court do not agree. Now, here I wish to pause on an aspect, and I wish to develop the concept which Justice Bahri raised in the beginning of counseling and counselors in the beginning. It is very important that the marriage should be sought to be resolved at a stage before it becomes ugly. In Bombay, the matter does not go before the judge till the counseling has taken place before the counselor and a report is received that the counseling has failed. Now, in Peri Consagra, Justice Lalit has authored a beautiful judgment saying that the reasons for the counseling having failed need not be recorded, but they have to be disclosed to the court so that the court can evaluate as to what went wrong. So if we were to have a counseling through expert counselors assisting the court, like we have the mediators in the High Court, where we have trained an entire set of very strong and eminent lawyers to assist the courts, maybe the infrastructure developing in your jurisdiction independently. It's up to you I can imagine your limited resources, but maybe if the High Court were to assist with the counselors being made available to you, you would probably be better equipped in finding your feet in this issue. Now, the next issue is that how do you resolve property disputes and child custody matters in limping marriages? Now, as far as the law on children is concerned, insofar limping marriages are concerned, our Supreme Court has very clearly said child rights are never conclusive. Factors change, circumstances may differ, parties may remarry. Children are never bound in a straitjacket as far as child rights are concerned. So, even if there is a settlement, your conscience is pricked, feel free to devise methods for changing the custody issues of children. I will develop this concept of shared parenting and joint custody tomorrow in this perspective because it's a very important issue which needs to be addressed. The second issue in limping marriages come on access to children. The spouse or the parent who has a child in India in a marriage in which there is an issue deprives the other parent. So it is up to you to find ways and means. If there is a maintenance issue, stop the maintenance, do a barter, do a trade. Some resolution has to be found on the issue or as far as this is concerned. Likewise comes settlement of matrimonial property. Now, overseas, the settlement of matrimonial property is done by a 50-50 rule. Whatever is earned before marriage, whatever is earned during marriage is all split 50-50. So you have men often coming down to India to do divorces in India because they think they will have to pay less. Because we have a need-based maintenance law. We have to satisfy what is our requirement, what is our need, and according to the proportionate need, the maintenance is awarded. Now, there are situations when the spouse is earning, the maintenance is reduced down. Now, in this circumstance, a block settlement of a lump sum alimony is the best proposition, and the Supreme Court obviously endorses this process also and comes to a consensus on this issue. Now, coming to the issue of second motion, which I left there. Now, I have in my paper addressed this issue. Supreme Court in Amardeep Singh versus Harveen Kaur 2017, Supreme Court 4417 has said, we have no power under 142 to dissolve a marriage on the ground of irretrievable breakdown of marriage. The power is under 13B. And the Supreme Court says that the provisions in 13B are not mandatory. They are only directory. So the Supreme Court says for waiver under section 13B2 and for the 6 months, Article 142 is not to be enforced. It is directory and not mandatory. It is a discretion of the family court to decide how you have to deal with this period. So if you find a matrimonial relationship has broken down, as I now see brilliant judgments coming from the appellate bench of Justice Ritu Bahri, that where a marriage is over, there is no point in keeping it alive. There is no need to force compatibility, cohabitation between parties. So if parties have gone apart from the very first day of marriage and 10 years have elapsed, I think 13B is the ideal example to apply. But then what is the status of the condonation period? Do you have to wait for 6 months for the same motion? Now, this is a discretion for you to exercise. If there is a motion in the application, in the joint petition, that we have been living apart for a year already, or more than a year, or more than 5 years, we have already dissolved the marriage, I think that 6 months period ought to be condoned. Now, there is no straitjacket formula. There is no hard and fast rule. You as the judge of your own court, you as the legal guardian of the family, have to come to a conclusion how you will treat this, and it is up to you to decide whether you wish to condone the period or not. If you think there is a chance of saving the marriage, some relationship exists, fine. Now, there is a divide. As Justice Ritu Bahri very rightly put it, every demographical jurisdiction differs on its needs, its requirements. You have a social strata under the poverty line. You have a social strata of earning groups. You have a high profile strata of double income groups in foreign jurisdictions. You cannot have a hard and fast rule for every category applying the same rule to all of them. Now, jurisdictions like Andhra Pradesh, where there are two independently earning spouses and the woman sometimes earning more, people often draw up a prenuptial contract before they leave India because they do not want to get into an ugly mess. But that is an elite requirement, and that is an argument of an exclusive category which will not apply to people. So where you find that the spouse is handicapped on account of lack of funds or resources, I think you're invoking the Legal Services Authority, which is now in existence in every jurisdiction, in every district, to provide a counsel free of cost to the concerned party can be the aim. And I think in such a situation, your requirement of deciding a Section 24 application for maintenance and litigation expenses should be a priority before deciding any other ancillary issue, because the question is only if there is going to be sustenance, be it 125, be it 24, or be the DV Act, can the litigation carry on. So whichever party is at a distress in a limping marriage, I think ought to need the redressal on this issue. So with this overview, I come to an end. I only wish I could answer questions, but that is of course not possible. Maybe when Lord Denning decides to do a physical conference wholeheartedly with the guidance of Justice Bahri, we will be able to exchange views and thoughts and have a dialogue to exchange views and learn from each other. Thank you very much.